Everybody to Central Library. My name is Sara de la Rosa, and I'm the librarian for the Latino Collection and Resource Center. We're honored to kick off 2026 programming with MACRI and welcoming Dr. Frank de la Teja. Before we get started, just a few housekeeping items. Restrooms are right through the door to the left. And before you leave, be sure to validate your parking ticket by the sliding doors and the little pillar. It says parking validation. You have free parking for up to 3 hours. After that, it's $5. And if you lose your ticket, it's $18. And we have a lost ticket at the table back there. So if someone can't find it, Carla has one. Otherwise, I'm going to go ahead and pass it on to Sarah.
Thank you so much, Sarah. Good afternoon, everyone, and welcome. On behalf of the Mexican American Civil Rights Institute, or MACRI, I want to begin by thanking Sarah de la Rosa and the wonderful staff at the San Antonio Public Library's Central Library. Thank you so much for hosting us this afternoon and for being such committed partners in making history accessible to our community. I also want to thank each of you for being here today. Your presence matters, especially as we gather for the first of MACRI's special programs commemorating the 250th anniversary of the founding of the United States of America. We do so at the end of a difficult week for our nation, one in which civil and human rights have once again been at the center of public attention and public concern. In moments like these, coming together to learn, to reflect, and to engage in thoughtful dialogue is both meaningful and necessary. Today's program is also an official Dream Week event. Dream Week is San Antonio's annual commemoration of the legacy of Dr. Martin Luther King Jr. And this year's theme is Revelations. We look forward to the revelations we may encounter this afternoon about our past, our present, and the responsibilities we share for the future. As I said before, this year marks the 250th anniversary of the U.S. Declaration of Independence, a milestone that invites reflection as well as critical questions. In this anniversary year, we ask, what does the United States semi-quincentennial mean to Mexican Americans? How have Mexican Americans shaped this country and contributed to its democratic traditions? And just as importantly, what do we want to see for our communities in the generations ahead? These questions are at the heart, or should be, at the heart of America250, the national commemoration of the nation's founding, and they're certainly central to MACRI's mission. So today marks the first in a series of special MACRI talks for America250, where we will highlight the ways Mexican Americans have been essential threads in the national fabric from the very beginning. So it's only fitting that today we begin the series with Dr. Jesus Frank de la Teja, expert in Spanish colonial Texas. His talk will explore rights in Spanish Texas, reminding us that debates over rights and laws and belonging long predate the founding of the United States. So let me tell you a little bit about our guest. Dr. de la Teja is a Regents Professor Emeritus and University Distinguished Professor Emeritus of History at Texas State University in San Marcos. He earned his PhD in Latin American history from the University of Texas at Austin, and earlier in his career, he worked in the Archives and Records Division of the Texas General Land Office. He has published extensively on Spanish, Mexican, and Republic-era Texas, and has served the historical profession in many leadership roles, including as board member, president, and executive director of the Texas State Historical Association. He served as the inaugural State Historian of Texas from 2007 to 2009. And his many honors include being a fellow of the Texas State Historical Association and the Texas Catholic Historical Society, as well as membership in the Texas Institute of Letters and the Philosophical Society of Texas. We are deeply grateful to Dr. de la Teja for sharing his scholarship and insight with us this afternoon. I know you're going to have questions, but I ask that you hold on to your questions until the end of his talk, and then we will have time for audience questions. And also after the talk, we can have some time to mingle and have some informal conversation, okay? I also invite you to check out the table at the back of the room where you can find information about upcoming MACRI programs and events. We also have some samples of our traveling exhibits on display in the back. Those exhibits are available for schools, community centers, and civic groups to borrow, and we're always happy to talk to you about bringing them into your spaces. So thank you again for being here, for your curiosity, and for your commitment to understanding our shared history. And now please join me in welcoming Dr. Frank de la Teja.
I think you'll be out before you have to pay the $5. I'm not sure. We're going to try. Let me just say that as I started working on this, it grew and grew and grew, and I was saying things that I knew required explanation, so I went back and added stuff. So this presentation is a mess, all right? But it's kind of a two-part mess. One that explores trying to understand where the behaviors of Spanish, Texas, Spanish subjects came from. And the other is some examples of the rights or behavior regarding rights. Anyway, so let's go ahead and get started. And we can begin, as we just found out, we got the 250th anniversary. The idea that all men are created equal is an aspirational 18th century novelty of Western political thinking that first made its way into the U.S. Declaration of Independence, even if the definition of what all men was very restrictive. In fact, in the Western tradition, there was a difference between everyone being a child of God and everyone enjoying the same earthly rights. In addition, we are also attached to the English common law tradition that we inherited from our imperial parent, and it is substantially different from the Spanish legal tradition that we're going to talk about. And it has been difficult, and I've spoken to lawyers. One of the things I do is I'm on the Texas Supreme Court Historical Society board, and I've spoken to lawyers. They get very upset at me when I tell them that the Spanish legal system actually worked, and that equity is an alternative view that has merit rather than just the common law and following precedent, which increasingly, with what has been happening in the courts in the last year or so, tells me it isn't a great advantage necessarily. But anyway, that's another talk for another day. In this first part, I want to go through the evolution of legal thinking that will find expression in Spanish Texas. What happens in Spanish Texas doesn't happen in a vacuum, which is unfortunately the way it's presented often in textbooks and the way it's presented to the general public. It's like it's just there, and it just happened, and it's not related to anything else. But it is. It's related to quite a few things. The Spanish Empire was based on the inherently hierarchical and monarchical system that descended from ancient polities. From the 15th to the beginning of the 18th century, it was corporatist in principle. In other words, your place in society was dependent on the group that you belonged to. Everyone had basic natural rights, but beyond that, treatment before the law was based on membership in some group. And under medieval worldview, the main job of the king and by extension his ministers, his appointees, was to administer justice to his subjects based on biblical and natural principles. Consequently, a Spanish subject would not have understood what someone meant by civil rights or even by human rights as we understand them today. The government did not protect people from discrimination. In fact, the crown often actually promoted discrimination. The government was entitled to enforce its views on religion and government policy. So, for instance, it was the Catholic Church's exclusive religion. Everybody had to be Catholic, or else. The government protected human bondage. So not only did slavery exist, as we'll see a little bit later, the crown actually, for a very long period of time, promoted slavery. And the government defended hierarchical and corporate social and economic relations. So very different than when we think about civil and human rights today. All right. What the Spanish worldview did understand was the idea of natural law, including certain rights. So, for instance, at bottom, to follow natural law was to act morally and justly. The foundation was that people were made in the image of God. And finally, that positive law could and did override natural law if it served a social good. And believe it or not, in certain respects, arguments could be made that slavery was a social good. All right, it was a social good for the people who benefited from it. So the Spanish inherited multiple traditions that contributed to its legal system and therefore to Spanish conceptions of personal rights and privileges. Roman law played a big part, as did church law. In early Visigoth Spain, the Goths and the Hispano-Romans operated under separate laws. We'll see how that applies to the colonial world in a little while. But with the conversion of the Goths to Roman Catholicism in 589, laws began to appear that applied to all subjects. In the middle of the 7th century, a new law code that combined Roman, Gothic, and canon law replaced the labels Romani and Gothic with Hispanic. So you begin to see the idea that different groups of people can be one, I won't call it wasn't nation, but we would use the word nation today. So Visigothic Spain did not last long, as the North African invasion of the 18th century not only brought Islam to the Iberian Peninsula, but broke up existing political relationships. The Moors allowed Christians to operate under their own laws, except where one of the parties was a Muslim. Although the Christian reconquest began almost immediately, within 10 years of the Moorish conquest of most of the peninsula, they lost the first big battle, and the reconquest began. Most of the peninsula was not in Christian hands until the end of the 12th century. In the process, various Christian principalities developed with their own legal frameworks, often employing the term fuero. And kings often granted or negotiated these with towns, institutions, and estates. So, for instance, the fuero militar, the military code of justice, we would call it today, a separate set of rules that apply to military men. But there were codes for towns. A town would have its own fuero. That charter said what privileges the town had and what the king could expect in terms of taxes and being able to adjudicate issues of various kinds with that particular town. So that was a mess too, because you have all these fueros, and some of them are with corporations, some of them are with organizations, some of them are with towns, and so forth. The Siete Partidas, and some of you may have heard about this, which was initially started up in the 13th century and found and was settled down in the middle of the 14th century, about 100 years later, was an effort by Alfonso X, who was called the Wise, and his successors to generalize the laws of the Kingdom of Castile and Leon. And that became the foundation of the various codes from the 14th to the 16th century that served as the basis of Derecho Indiano, which is the term that's used in the Spanish legal system of the New World. Derecho, there's no direct equivalent of the word derecho in English. It's often translated as law, like in law school. You don't say escuela or colegio de leyes. In Spanish, you say escuela or colegio de derecho. Derecho is a combination of law and justice. So if you think about it that way, it's a different attitude toward thinking about how the law works. The principal thing is justice rather than the statute or the code or the individual judgment. The governing principle is justicia, justice. Just as the Goths and the Moors had faced the problem of governing populations with very different legal systems, the Spanish faced the problem of governing the vastly larger Indian population of the Americas. The result was a development of sets of laws or codes. Again, it's not the English common law, so it isn't judges that are making the law by adjudicating issues. It's the crown making use of legal experts who come up with laws that are supposed to govern the way things operate. The result was a development of sets of laws and individual decrees that very quickly began to accumulate. The laws of Burgos, 1512, the first effort to codify relations between colonizers and indigenous people. This code came before the major conquests of the mainlands. So even before Cortés got to Mexico, the Spanish were already trying to come up with a system of rules for how to govern and how to treat people in this new world. The laws of Burgos, however, established or codified certain practices that had developed in the early Indies. So for instance, encomienda, or the holding of Indian to service or goods requirements. In other words, if you had Indians, and encomendar means to entrust. So if you can think of an encomienda as a trusteeship. So who was being entrusted? The Indians. How were they being entrusted? Well, they were being given over to the authority of the encomendero, of the trustee, who was responsible. So it's a two-way street. He gets their labor, or he gets goods from them, and in return, he is supposed to provide them with a religious education and protect them. Didn't quite work out that way most of the time, but that was the principle of the encomienda. The Indians were also recognized as free people, and this is something that's good. We're going to talk about in a minute. But from the very earliest days, even before Isabel died, she's already concerned that her new subjects, and that's how the Spanish monarchs thought of the Indians. They are subjects of the crown, so they are the crown's responsibility. Remember what I said earlier about the principal job of a king was to dispense justice to all of his subjects. So this is an ongoing concern in the Spanish world. It was heavy on religious instruction, which the Spanish crown saw as the most important justification for the conquest, given that Pope Alexander had granted dominion over the new discoveries to the kings of Castile for the purposes of evangelizing the crown's new subjects. So again, a quid pro quo. I get dominion over you, and in return, I save your soul. Doesn't that work out great? The next set is the new laws of 1542, which were a codification of indigenous Spanish relations given the conquests of Mexico and Peru. Although the laws met considerable resistance and were never fully enforced, and their considerable resistance included a rebellion against royal authority in Peru, including by the Pizarro brothers. So the guys who conquered Peru on behalf of the king then rebel against the king because they try to oppose these laws that will cut them out of getting maximum work out of the Indians, essentially. The new laws also included a heavy dose of treating the Indians as free people, prohibiting their enslavement under any circumstance. That's not going to happen either. And under any pretext, and also granting, also ending the encomienda grants after one generation. The idea was that these are subjects of the crown has entrusted them to individuals. At the end of the life of that individual, they return to being subjects of the crown. It's kind of feudal in thinking, and we don't have time to go into that whole feudal thing, but it's also not feudal. So the New World is shaping up as something new, and the Spanish are trying to deal with the new circumstances. The question of the status of the crown's indigenous subjects continued to bother the conscience of Spanish monarchs until the end of the colonial period. It's not surprising. It's one of the things that happens if you get older, your fingers don't quite want to do what you want to do. Charles I ordered the first official debate on the subject in 1550. In what is known as the Valladolid debate, Bartolomé de las Casas as the champion of the Indians, and Juan Inés de Sepúlveda as the champion of the just cause doctrine, the just war doctrine of conquering people, if you will. And scholars associated with each camp debated the nature of the Indians and their rights. The jurists who oversaw the debate scattered without reaching a final decision, which tells you something about just how difficult it was to come up with something that would work. And the crown spent the next 300 years trying to balance the interests of its Indian subjects and the desires and demands of its Spanish subjects. Many scholars consider the debate the beginning of the search for human rights. So the launch of the history of the human rights, the idea of human rights, modern human rights, begins with that debate in 1550. Charles's son Philip was also concerned that the previous codes had not brought about the desired effects of fair and just treatment to the Indians. And by the way, I'm focusing on the Indians here because if you're Spanish, you know where you stand, because all Spanish law applies to you. The problem is how to get this law to work in the New World where you've got these two very distinct populations. So Charles' son Philip was also concerned with the previous codes had not brought about the desired effects of fair and just treatment of the Indians. In 1571, he ordered a reconsideration of the existing legal framework for the American colonies, and the result was the laws of the Indies, also known as the New Laws. This effort to codify colonial law included an end to wars of conquest, but allowed for pacification campaigns, kind of like we're going to turn the war in Southeast Asia into the pacification of Vietnam. So those of you who are older remember that. They stopped using the word war, but they would use pacification or police action. So this is what it's a legal nicety, if you will. reinstated an end to Indian restated, an end to Indian enslavement, and prescribed how, where, and by whom new settlements and provinces were to be founded. The best known code of Spanish colonial law is the Recopilación de las Leyes de los Reinos de las Indias of 1680. Normally we just call it the Recopilación because it's the title is way long. It was, and you can see that it's even, and it's a big deal. It's 4 volumes. It was an effort at a comprehensive compilation of laws issued for the Spanish overseas possessions. But before and after, there were decrees specific to places or groups and major codes that begin to appear separately in the 18th century after the Bourbons take over the Spanish monarchy, which sometimes contradicted what was in the Recopilación, which, by the way, remains valid to this very day as an underlying principle of law in Spanish America and even in places like Texas. Where if you can't solve a land or water issue based on positive law that has been passed by the legislature or whatnot, and there's no precedent, then you wind up going back to the Recopilación, and you can go even further back to the siete partidas. So there's in American, Texas, California, Florida, other places that were under Spanish rule, there is still reference to that Spanish law, usually not having to do with people's rights, however, so we'll leave that for the moment. So now that we have a general idea of the evolution of Spanish law for the Indies, we can start to see how it operated based on how the Spanish applied their traditions to the regions they conquered. First, just as in Spain, the crown distinguished between people based on religion, Christians, Jews, Muslims. The people subject to the Spanish crown in the New World fell into 2 broad categories. República de Españoles, who were considered the gente de razón, or people of reason, rational people, and the República de Indios, which is all of the Indians everywhere who lived as Indians, and who were referred to as gente sin razón, or irrational or non-rational people. And it didn't mean that they couldn't reason for themselves. It meant that they couldn't operate within the rational system that the Spanish operated in. In other words, it's like what the Greeks used to call barbarians, right? We're Hellenes, we're Greeks, and everybody else is a barbarian, which means they're not quite up to snuff, right? And so that's how you think about the Indians. And so the Indians were subject to tribute. They were the underclass. So except for Indian nobility, the Indians were subject to tribute. Spanish subjects in the New World were not. They might have been back in Spain. They might have had the pecho, which was the Spanish head tax in Spain, but there were no pechos in the New World. Instead, there's a tribute requirement of the Indians. And we don't have time to go into it because it gets complicated. But the bottom line is that the Indians are subject to tribute, they're subject to encomienda in certain circumstances, and they are subject to repartimiento. They are subject to forced labor on behalf of the crown or crown officials, and these often sell that labor requirement to a local landed individual who needs work, or miner who needs workers, and so you have repartimiento of the labor debt that Indians owe is then turned over to private parties. So it can be dicey but the Indians hold their own. The República de Indios was never perfectly constituted for a variety of reasons. For one thing, it proved impossible to keep Indians and non-Indians separated. Spaniards, including Cortés, found wives and concubines among the indigenous nobility and produced little mestizos. They're running all over the place. So now you've introduced the problem of how do you differentiate people if now they're all mixing, right? Spaniards and Africans will find wives among Indian women, commoners. So you've got this process of mesticization that's going on. It's kind of like semi-quincentennial. Say that 3 times faster. Some words are just hard. Anyway, the bottom line is that the later acculturation led to even more mixing and flight from Indian communities. If you were an Indian and you learned Spanish well and you learned your prayers, and so you were fully functional in Spanish society, then what the hell? Run away from the village so you don't have to pay the tribute, right? And you can just call yourself a mestizo. So who's going to tell the difference, right? So that creates a problem. In their communities, sedentary Indians were allowed to govern themselves so long as their laws and customs did not clash with Christianity or particular laws. But that meant that these Indians in their communities where they accept that other people are moving in. They're not exclusive. We're running our own show. We can do whatever we want. And usually a priest might visit every once in a while. The encomendero might show up. Most Indian communities never saw a royal official. The closest they got was a priest. So they pretty much ran their own shows. And of course, mestizos start moving in, and others start moving in. And it's hard to keep these communities exclusively Indian. So long as they're among non-sedentary Indians, that is the Indians that you find in most of Texas, with the exception of the Caddo up in East Texas. The missionaries tried to keep their charges separate from the Spanish, but that also didn't work. We know that, for instance, at the missions here in San Antonio, from the very beginning, soldiers had to go and be there at the mission. The soldiers brought their families. Soon there weren't enough Indians to do some of the labor, so the missionaries contracted with people from town to come and live at the mission. So it was impossible to have separate repúblicas de indios and repúblicas de españoles. The República de Españoles, however, was an even more complicated concept, since it took everyone who was not an Indian into account. First, it was comprised of the various ethno-cultural groups. So there were 3 primary groups. There were Spaniards, Indians, and Africans. And the latter 2, by the way, were tributary. If you were an African but free, you owed the tribute. And if you were an Indian, you owed the tribute, but not if you were Spanish. And then there were the castas, those little mestizos running around. But they could be Spanish and, they could be Spanish and Indian. They could be African and Indian. They could be Spaniard and African. And then they could be a mixture of all of it. And in the late 17th century and the 18th century, it became a popular art form to kind of depict all of these various mixes. Some of them are pretty funny. I like this one in particular because it does do a more realistic job. Go home and Google and see all the various representations. Some of them are very, very fanciful. Anyway, bottom line is that racial mixing meant that the rights and privileges were based on apparent ethnicity rather than on actual race. For instance, some mestizos could pass as españoles. Blanco was never used. In the Spanish, you were either an español or a criollo, but there's no reference to blanco. The color does not enter into it. It only enters into it with Africans. They are black. They can be black. Negros. Some mulattoes could pass as mestizos. Some Indians could also pass as mestizos. And on the northern frontier, places like Texas, the lines were even more blurred because of the small Hispanic population to begin with. So mission Indians had the protection of missionaries and were favored under the law, which technically treated them as wards of the crown, and the missionaries, as you'll see in a moment, in one instance, the missionaries could actually actively work to incorporate their charges once they were acculturated into that Hispanic society, which was all all mixed up anyway. So although Spanish law included formal trial system, the lack of letrados, that is titled jurists, guys who went to school, meant that the sumaria system, and I'll talk about that a little bit later, prevailed in frontier regions like Texas. Less formal than the plenario trial procedure, which was very elaborate. It allowed experienced but unschooled officials, either prominent vecinos, acting as judge or as attorney for one of both parties, or government officials, usually military men, to act in the first instance, and in the governor's case, in second instance. So you have this big overhead of law and justice and everything, and then at the end of the line is places like Texas, where nobody wants to come, and so the people who are here are the people who, for one reason or another, like the fact that it's the wide open spaces. It's kind of wild, and they're going to do things on their own, and there are no lawyers, and very few public officials. There's certainly no jurists around. So, while the system functioned, it could be frustrating, both for the litigants and the unschooled jurists involved. Take the case of Felipe Flores, who was arrested but not charged, right? He was arrested but not charged by Alcalde Fernando Veramendi. His son, Juan Martin Veramendi, will become governor of Coahuila, Texas, and his daughter will marry Jim Bowie. All right, so we've got a pedigree here. Fernando Veramendi for adultery on the accusation by the parish priest. Veramendi, a Spanish merchant who had settled in San Antonio in the 1770s, was typical of the prominent vecinos who were tasked with serving as alcalde. An alcalde is, we translate the word as mayor today, but back then they were not mayors. They were magistrates. Their jobs were as jurists. They were judges of first instance. They were also administrative and executive officers. Men such as Veramendi did the best they could, using common sense and resorting to the copies of the few legal texts in the town council archive, usually a copy of the recopilación that looked very much like the picture I showed you a little while ago, a manual for scribes and notaries, and a collection of edicts, decrees, and other surviving copies, which can be found to this very day in the Bear Archives. There are still copies of some of these things. But back to Flores. The governor soon ordered Flores' release and reprimanded Veramendi, who for jailing him but not charging him. Right? So a due process. Even there's no idea of just, yeah, you're in jail, so what? Too bad. If you're in jail, you can appeal, right? And the appeal worked. The governor soon ordered the release and then reprimanded Veramendi, who defended himself. He did not know whether the circumstances warranted a formal charge. The priest asked me to arrest this guy, so I arrested him. I don't know. It was not the custom in San Antonio to have such charges filed before the alcaldes. And nor were there instructions in the Cabildo archive on how to handle such charges. The bottom line was that, as Veramendi saw it, he could hardly be held responsible, as he was only a merchant. I'm doing the best I can, right? I'm not really a judge. So how did the Spanish system work in regard to individuals in Texas? So, for one thing, punishment depended on status. In 1745, Alcalde Juan Montes de Oca issued an order prohibiting small weapons, such as knives, in town, under penalty of 12 pesos fine and 8 days in jail and the loss of the weapon, except in the case of castas, or the people who were of mixed race, who were subjected to 200 lashes and 1 month at public works in the Villa and Presidio. In 1751, Alcalde José Padrón issued an order requiring anyone going out to slaughter cattle with the mission foreman to obtain the permission of the missionary, under the penalty of 25 pesos for Spaniards and 200 lashes and banishment from the town for castas. One of the most extensive good government ordinances appeared in 1761, when Alcalde Alberto Lopez, among other things, issued a set of ordinances that included the requirement that unemployed and shiftless people find a master within 3 days or leave town. All right, so think about the right that you have to move freely. About your freedom of movement, it doesn't exist. We want to protect the town from vagabonds, shiftless people, no goods, and so either get somebody that's going to control you or get out of town. The interesting thing about the bando was that it did not distinguish between people of different ethnic groups. On the other hand, Governor Riverdal's 1770 edict against theft included some harsh consequences depending on the amount stolen, including the pillory, lashes, public works, banishment to work in the mines or other hard labor, and if blood was spilled in commission of the crime, even capital punishment. Although I have yet to find an instance in the 18th century of capital punishment actually being applied in colonial Texas. The edict did provide that, quote, even hidalgos will be held fully accountable. That's I guess, a reference to the Canary Islanders. They're running around saying, we're hidalgos, we're special. And so Riverdal says, even hidalgos will be held fully accountable, except that they will be able to provide a peon to do the labor for them. Okay? So you could be convicted, you could be fined, but then you could pay. Well, you know, in the Confederacy, when it passed its draft law in 1862, made it possible for you to buy out by hiring somebody to take your place. So the plantation, the scions of the plantations didn't have to go if they didn't want to. They could buy somebody in to take their place. Anyway. But yet that's yet another story. There are other examples of what we would consider unequal treatment, but would have been perfectly understandable at the time that what I'm talking about happened. I have written about two specific cases, both of which have appeared in the Southwestern Historical Quarterly. The first is why Urbano and Maria Trinidad can't get married. Social relations in late colonial San Antonio. And that appeared in 2008 and is in, this is the shameless plug right now, in my book, Faces of Teja, which you can order right now on Amazon. You have it on your phone. You know you do. And the second is more recent. It's the treason case of Erasmo Seguin, a story from Texas's first War of Independence, which appeared in 2022. The first case concerned Urbano, a Mission de Valero Indian who wanted to marry Maria Trinidad Gámez, originally from Los Adais, and the daughter, sister, and niece of soldiers. In 1781, Maria Trinidad's uncles and stepbrothers complained directly to Governor Cabello that Gertrudis Perez, Maria Trinidad's widowed mother, had been manipulated by Valero's missionary to marry her underage daughter to an Indian from the mission. As soldiers and Spaniards, they objected to the marriage, and they based their appeal to the governor on the basis of the Pragmática Sanción of 1776, which regulated the marriage of individuals under the age of consent. In the Spanish world, being 25 years of age. And by the way, this is one example of the codification of law during the Bourbon period that replaces parts of the Recopilación or replaces other Spanish law and canon law even, because this, in regulating marriage, it says that the crown has authority over the church. The church did not say that you had to be of the age of concern, only that the two people involved had to freely enter into the marriage. So priests would, and which is why gets passed, priests would often marry kids who were 16, 17, 18 years old, and the parents couldn't do anything about it. And so this was an set of laws that will stop that kind of behavior, because the Crown has an interest in making sure that the paterfamilias and other parental units are in charge. So anyway, this is where things get interesting. Because rather than the missionary nor Urbano, neither the missionary nor Urbano accepted the initial judgment. Rather than appealing to the governor, they took their case to the parish priest, who was known to be an adversary of the governor. In the course of the proceedings that followed, Urbano alleged that neither Maria Trinidad nor her family were Spaniards, but mulattoes, so that they could not claim to be of higher status. That means they couldn't claim any privilege or rights because they were not entitled to such. He also pointed out that neither the uncles nor her stepbrothers had standing under the Pragmática Sanción, which gave the authority to Gertrudis, Maria Trinidad's mother. He also pointed out that she was not too young to marry, since she was 13 years and 5 months old, and she knew all the principal prayers. Yes, you were not too young to marry at 13 and a half. The fact that she had been deposited in somebody's house, because there wasn't a jail for women, so what you did is you took women and you put them in the home of somebody who was of known good repute. So they kind of kept a watch on you. 2 months the girl had been there, and after 2 months she still wanted to marry Urbano. So that proved that this was not a forced marriage. One last jab was that Maria Trinidad's aunt had herself married Jose Maria Camberos, an Indian who was so new to the faith that his baptism and marriage took place at the same time. So, kind of hypocrisy going on. We can assume that Urbano did not come up with these arguments on his own, but in the appeal we see how complexities of race, hierarchy, the law, and religion all manifested themselves with this 13-year-old girl caught in the middle. The soldiers responded to all of these allegations and reaffirmed their standing on the basis of Gertrudis being a woman of bad character. I don't have time to go into the case in depth, but I want to point out that Governor Cabello did not act arbitrarily. Once he saw that the case was a lot more complicated than his legal talents could handle, Cabello sent the case to a lawyer in Saltillo, 350 miles away. That was the first lawyer. The closest lawyer was, wouldn't that be nice? And the closest lawyer to San Antonio was 350 miles away. For legal opinion, with all due respects to any lawyers in the crowd. Unfortunately, that opinion has not surfaced. In the months between sending the file to Saltillo and early November 1781, Urbano had a change of heart. He decided to wed a widow from the mission and released Maria Trinidad from her betrothal. My interest in the case was not from the perspective of legal analysis, but I think I analyzed it enough from other angles, particularly the interplay between gender, race, status, and someone reading it, for someone reading it to understand how legal rights played out, and so can get a lot out of it. The other case I have written about involves Erasmo Seguin, the father of Juan Seguin of Texas Revolution fame. As it happens, Erasmo was an extremely important figure from the beginning of the 19th century to 1836, including having served as Texas representative to the Congress that wrote the Federalist Constitution of 1824. Among the important aspects of his 1813-1819 treason case is how it demonstrates how the Spanish justice system, even the military justice system in place during what was not as arbitrary as is often portrayed. Because we have the entire file from beginning to end, including the evidence, I did spend a considerable amount of time explaining how the Sumaria information process operated. In fact, the article contains a complete translation of the case file. One of the things that happens when you retire after having been a faculty member is that your vocal cords soften up. So when you give talks like this, you dry up when you're teaching, you're just yelling at people anyway. The case is equally valid for understanding civilian and military cases, since except for how appeals were handled, they worked exactly the same way. First, there was the juez procurador, or prosecuting judge, whose job it was to gather evidence, examine the accused and witnesses, and issue a decision, which in a military case needed to be confirmed by the court-martial. The case was then sent to the Commandant General for final review. So although there was no court trial, certainly not in the common law sense of a trial, there was an opportunity for the accused to make his case, present the challenged witnesses, and appeal the judgment. Pedro Lemus, the prosecuting judge, took testimony and heard Erasmo's explanation of how he had supplied letters of introduction that implicated him in the activities of rebels that had captured the province in the spring of 1813 and who had been defeated in August at the Battle of Medina. To make a long story short, Lemus did not believe Erasmo's explanation that he had written letters of introduction for the rebel Jose de Toledo under duress, and found him guilty, recommending so there's no jury, there's no attorney representing each side. The judge is also the prosecutor, and he gets to make a determination, recommending a 5-year prison sentence. Here's where it gets interesting, because the full court-martial decided that Lemus had not given enough consideration to Erasmo's explanation of his actions. So it ordered Lemus to go back and expand the investigation. In spring 1814, after additional testimony, Lemus again found Erasmo guilty, and again the full court accepted Erasmo's plea that he be given an opportunity to address Lemus's concerns in light of letters written to Erasmo by known royalists. Finally, in February 1814, and I don't know if it's just because he gave up or he really was convinced by Erasmo, Lemus agreed that there were enough contradictions in the case that Seguin should be released on bond while obtaining affidavits from Natchitoches regarding his conduct while he resided there. It took 4 years for Erasmo to get the affidavits from Natchitoches, where he had written the letters and where he had remained until fall 1813. And the letters described him as a loyal Spanish subject. At this point, the entire file was sent to the Commandant General for final disposition. General Arredondo turned it over to his judge advocate, Rafael Del Llano, a letrado attorney, that means a licensed, qualified attorney, who wrote an opinion based on his analysis of the evidence, on the appropriate codes of law, even citing the partidas. Not only did Llano opine that Erasmo should be declared innocent, but that whatever property that had been taken from him that was still available should be returned to him. Arredondo did what Commandant Generals almost always did and accepted Lemus's opinion. So it wasn't Llano who was making the judgment, it was the Commandant General based on the opinion of his advocate general. Erasmo, who might well have been executed had he been captured in the days following the August 1813 Battle of Medina, was fortunate enough that following the heat of battle, the justice system returned to well-established procedures and a concern for justice. So my point here is, and if you read the accounts of Jose Antonio Navarro and so forth about what happens at the Battle of Medina and how people are executed in the square in San Antonio, and in other places I've written about the fact that months later the parish priest is asking the governor, please let me take down the bodies of the men that are still hanging in the plaza. This is 6 months later. bodies are still hanging there because the children are desecrating the bodies. And if live rebels have been pardoned and are walking around free, why can't we have some dignity for ones who weren't so lucky? So it's a very interesting dimension to things. So let's go on to the second case, or the other ones. Aside from these cases, I have written about women's issues, including their rights in various places. But most importantly, in a 2023 article in the Southwestern Historical Quarterly, Women's Lives in Spanish Texas Community, San Antonio de Teja, 1718 to 1821. Although it is a general article on a broad range of topics, I do deal with women's rights. For instance, women had property rights, and as widows in particular, they had full control of the property they owned. This property right was irrespective of race and status. Women's property rights were such that those who owned their own cattle could have their own separate brands to distinguish their animals from those of their husbands. Women also had the right to seek justice in their own right, as when Antonia Hernandez, a free mulata, went before the governor to plead for the return of her 8-year-old son who had been taken from her by her former employer. The governor sided with her against one of the early San Antonio's most prominent vecinos. In 1810, Maria Antonia de Abrego sued her husband for her portion of the 200 pesos he had incurred in gambling debts. Maria Rosa Perez pled before the visiting Commandant General in 1778 that Father Fuentes had unjustly had her deposited for adultery. The Commandant General agreed, ordering her release and admonishing the priest that he lacked authority to punish anyone for adultery. On the other hand, until the decree of 1779 granted parents the right, 76, to grant the parent the right to approve the marriage of their underage offspring, it was the contracting partners alone who had the right to marry. Even after 1776, women had the right to accept or reject a union. Church law also provided rights to enslaved individuals who had the right to marry whoever they chose, whether enslaved or not, which made it very interesting because once married, they could not be separated. The church prohibited it. So it created a burden on the enslaver because if he was to sell one, he had to sell the other partner along with it. Even slaves had rights. So in 1798, when the enslaved Maria Manuela Fuentana wanted to marry Jose Manuel Rodriguez, they obtained the permission of their enslaved parents rather than their enslavers. Right? So parental rights override anything else. In fact, some cases give us clear evidence that the enslaved not only had rights, but that they knew it. Maria Simona de Jesus, a Zambrano family bondswoman, understood well that she did not have to accept extreme abuse. Mariana and her enslaved husband, Felipe de Fierro, ran away after Zambrano's daughter slapped Mariana and verbally abused her. No amount of persuasion could induce them to return. The Zambranos even complained that the authorities had accepted the word of the enslaved over theirs. In the end, the Commandant General's Council found that although enslavers could be forced to sell a bondsman if the sale was for the purpose of freeing the individual, a master could not be forced to sell to another enslaver unless there was evidence of abuse or neglect. Since Mariana, who was 50 years old, had not previously found a buyer at the price that Zambrano asked and had returned with her husband to the Zambrano household, the pair could no longer claim that the abuse that they had alleged was a valid reason to be sold. So the law weighed the evidence. It used the law, the judges weighed the evidence and used the law to make a determination, and that determination could go either way, but it was, in fact, justice. While the rights of enslaved people of African descent may have stopped short of their right to liberty, that was recognized in natural law, enslaved Indians. I'm almost at the end, folks. Hang in there with me. Who knew that the practice was illegal, did have recourse to justice. Maria Gertrudis de la Peña, an Indian woman from the Camargo area, so down the valley, had been sold by José de Bocanegra to Pedro José de la Peña in 1768, despite laws prohibiting the enslavement of Indians. Maria Gertrudis had stayed with Peña until 1782, when he decided to sell her to Antonio Oquillas to cover up his having made her pregnant. Her child died a few days after birth, and she grew dissatisfied with her service to Oquillas, who then sold her to Navarro, who brought her to San Antonio. However, this is Jose Antonio Navarro's father, by the way. However, finding service in the Navarro's house intolerable because of the abuses received from him and his family, she appealed to the governor for relief. Domingo Cabello declared that all of the sales were null and void, that Maria must go free, and that since Navarro did not have to pay Oquillas the 50 pesos in agreement, Oquillas was free to sue Peña for the amount. Another case demonstrates what I said earlier about the rights of Indians being separate from those of non-Indians, Spanish subjects. In June 1776, Maria del Refugio de Jesús Santa Maria, who was brought before the governor to testify in Francisco Arocha's trial for his murder of her husband, Jose Antonio Vallejo, Arocha, an Indian born at Mission San Jose, eventually admitted to killing Vallejo, but implicated Maria Refugio, who was of Hassanite origin. In other words, she was a Catholic. Fortunately for them, as Indians, they were exempt from capital punishment. So Governor Rivera sentenced them to 7 years of banishment. Nevertheless, Spanish society was patriarchal, and the male head of the household held both rights and obligations as paterfamilias. In 1809, Governor Manuel Salcedo issued a set of good government ordinances, among which was the following, quote, "The husband who permits his wife to be out after hours, or his single daughters, or other persons under his roof, will be punished as if he were the offender. And the same goes for fathers in regard to their sons and servants." So no hanky-panky. If rights were based on sex and race, they were also based on status. In the case of San Antonio, one important aspect of status arose from the arrival of the Canary Islanders and the founding of San Fernando as a town, separate from the Presidio, in 1731. Since they came with a royal charter, the Canary Islanders claimed exclusive rights to land, water, and management of their new town. As they claimed a few years later, as part of the suit against them, quote, "The laws of the Indies do not concede the same privilege to those who come to reside as to those who settled the area, nor is there any reason for it when the latter, abandoning their own fatherland, travel to such distant and remote lands with untold perils to their lives, while the former found the land quiet and some degree safe." The complaining settlers pointed out that this was horse hucking, that it was they who were the true original settlers, having come to San Antonio a decade before the Canary Islanders, and that the Isleños had benefited from the work that they had done to settle and open the land. The case was eventually resolved with an agreement to appoint one alcalde from each group and to allow the settlers to join the cabildo. I want to end with the first recorded murder in Texas history. It happened in 1730 and involved Felipe de Avila, having shot Nicolas Pascual 2 months after Avila caught Pascual in bed with his wife. The governor conducted the initial investigation in April, which uncovered, pardon the pun, that Avila had come home to find Pascual naked in bed with the lady, and Governor Mediavilla Escona sent his findings to Mexico City. But the attorney in the audiencia who reviewed the case responded in June that the paperwork was unclear. In other words, you have people who are not really lawyers and judges doing the paperwork, and they had not done a good job. So do it again. And so at the end of July, the governor acknowledged receipt of the instructions and conducted further investigations, during which it came out that it wasn't the first time that Avila's wife and Pascual had been found together, but that Avila's wife pled that it was Avila who had been bothering her, molestando. Me estaba molestando. She's bothering her. Mediavilla Escona, the governor, now sent the file back to Mexico City, which acknowledged receipt in September. The final decision is undated, but it found that Avila was justified in his actions. Although he was ordered to be transferred to the Presidio of Rio Grande, he was exonerated, in other words. So while the case may have taken most of the year to resolve, officials in Texas, and by the way, that wouldn't have been cheap. You had to send all this stuff hundreds of miles to the south. It has to come back. It has to go back the other way. It's time-consuming and expensive, right? So nobody is being flippant about the law and justice. It's taken seriously. The attorney in Mexico City isn't, oh, it's from Texas, whatever. The attorney reviewing the case in the audiencia weighed the rights to life of the deceased against the marital rights of the accused, and found in the crime of passion that Avila had not acted unreasonably. Right? So, what I have found over and over again is that the cases I've noted above repeated numerous times. Given the frontier circumstances of 18th century Texas, what we might call the basic rights of people of every condition were taken seriously. The system may have been very different from what Anglo-Americans brought with them in the 19th century, but it was no less effective in meeting the needs of Spanish Texans, especially given what we later see in things like Jim Crow and lynch law and discrimination toward Mexican Americans in the 19th and first part of the 20th century. So I'm not saying the Spanish system was great, but I am saying that we need to study it and understand how it operated for the people that it affected. And was it effective? And the bottom line, and I'll end it here by saying, was that for most people, the system worked and they accepted the verdict. Thank you very much.